does not go far enough. Voters on opposite ends of the spectrum may be counted as having expressed the same opinion. Therefore, there may be specific circumstances in which a binary question is unable to capture the views of the electorate. Secondly, binary choices can encourage polarization. Campaigners are incentivized to present the two options as completely opposed to each other, encouraging voters to position themselves as for or against with little room for nuance. This can increase the focus on political or even societal divisions rather than on common goals or positions, and promote an adversarial rather than deliberative approach to debate. Drawing upon evidence from the Swedish multi-option referendum, it was suggested that a multi-option referendum debate may be less divisive than a binary referendum, as opinion will be less polarized. Furthermore, multi-option referendums conducted through preferential voting would offer voters a choice as to what they would be prepared to compromise on should their first choice not win support. It was, however, noted that multi-option referendums are therefore only advisable if they are justified by the underlying spread of opinion. They are most appropriate where a number of distinct, clearly defined options already exist and when opinion is clearly split between them. We have set out the foregoing in order to show that not only is it possible and sensible that proposed amendments be submitted as separate and distinct referendum questions to the people in the referendum ballot paper and to be voted for or against separately, but also on occasion it may even be necessary to conduct multi-option referendums. In our scenario, Article 255(1) of the Constitution provides that a proposed amendment to the Constitution shall be enacted in accordance with Article 256 or 257. In our view, what the Constitution contemplates is that each amendment to the Constitution shall be considered on its own merit and not within the rubric of other amendments. We opine that the drafters of the Constitution were alive to the fact that a bill to amend the Constitution may propose different amendments to the Constitution, some of which may be agreeable to the voters, while others may not. In such event, to lump all such proposals together as an omnibus bill for the purposes of either laundering or guillotining the whole bill is not permissible under our constitutional architecture. Not only does such a scenario lead to confusion, but it also denies the voters the freedom of choice. For instance, the Constitution Amendment Bill under consideration contains at least 74 proposed amendments to the Constitution. A faithful reading of Article 255(1) of the Constitution yields the conclusion that each of the proposed amendment clauses ought to be presented as a separate referendum question. This not only avoids confusion, but it also allows the voters to decide on each presented amendment question on its own merit. For example, a voter might be persuaded that Clause 50 of the Constitutional Amendment Bill, which proposes to amend Article 203 of the Constitution to increase the percentage of funds allocated to county governments from 15% to 35%, ostensibly to strengthen devolution and ensure that county governments have adequate funds to carry out their operations, merits passage. However, the same voter might be similarly persuaded that Clause 10, as read together with Clause 74 of the Constitutional Amendment Bill, creating 70 additional constituencies and allocating them to specific counties while directing the IEBC on the apportionment criteria is unconstitutional and ill-advised. Such a voter will be forced to vote for an outcome she does not want. And the promoters would have succeeded in laundering Clause 10 and 74 of the Constitution Amendment Bill into passage, notwithstanding their cumulative unconstitutionality. In the preamble to the Constitution, the people expressed that in adopting, enacting, and giving to themselves and to their future generations the Constitution, the people were, inter alia, exercising their sovereign and inalienable right to determine the form of governance of their country. That right belongs to each and every individual who ought to be given an opportunity to have a say in every question that is proposed to be voted upon. We agree with the opinion expressed in Olum and another versus Attorney General that the preamble of the Constitution should be given effect wherever it is fairly possible to do so without violating the meaning of the words used. Our view on omnibus amendments is supported by Section 49 of the Elections Act, which provides, and we have reproduced the section there. Our understanding of this section is that what is to be subjected to the referendum is the question or questions as opposed to the Constitution Amendment Bill itself. It is therefore our finding, and we so hold, that Article 257.10 requires all the specific proposed amendments to be submitted as separate and distinct referendum questions to the people in the referendum ballot paper and to be voted for or against separately and distinctively. We now turn to the import of omitting the Independent Constitutional Health Services Commission from the Constitution Amendment Bill. For this part, we would like to omit it and let the parties will read that. So we'll move on to the next part. Yes, the next part, and it states that the Constitution Amendment Bill at Clause 10 states in the margins, amendment of Article 89 of the Constitution. The clause then states, Article 89(1) of the Constitution is amended by deleting the words 290 and substitute therefore with the words 360. Clause 74 reads in the margin, transition and consequential provisions. The clause states, the transitions and consequential provisions set out in the second schedule shall take effect on the date this act comes into force. The second schedule indicates that it is made under Section 74. It provides for the delimitation of the number of constituencies and states that within 6 months of the commencement of the Act, the IEBC shall, subject to subsection 2, determine the boundaries of the additional 70 constituencies created in Article 89(1 using the criteria in Article 81(d) and 87(7). The 70 constituencies shall be spread among the counties set out in the first column in a manner specified in the second column. The petitioners set out the particulars as follows. Clause 10 of the bill proposes to amend Article 89 to increase the number of constituencies from the current 290 constituencies to 360 constituencies. The object stated is to facilitate the attainment of fair representation in the National Assembly and to actualize the aspiration of the equality of the vote principle, especially in the currently underrepresented electoral areas. The prayer sought by the petitioner set out in this part, and from the petition, responses and submissions, 2 issues arose. Is it lawful for a constitutional amendment bill to set a specific number of constituencies under Article 89(1) of the Constitution? Is it lawful for a constitutional amendment bill to directly allocate and apportion the constituencies it creates without a delimitation exercise as set out in Article 89 of the Constitution? The main arguments by the petitioners on these 2 issues are that the second schedule of the Constitution Amendment Bill is proposing an an unconstitutional amendment to the Constitution on various grounds. 1. That it amounts to the usurpation and deliberate undermining of the authority of the IEBC. 2. That the IEBC is a Chapter 15 commission established under Article 88 of the Constitution with specific authority, mandates and functions which are further extrapolated under the provisions of the IEBC Act No. 9 of 2011. 3. That the provisions in the second schedule of the Constitution Amendment Bill amount to a violation of Article 89 of the Constitution by supplanting and usurping the powers and roles assigned to IEBC by the same Constitution, and Article 10 by taking away the right to public participation, which is an indispensable imperative for boundary delimitation. 4. That the roles and functions of the IEBC and the mechanisms for delimitation of the constituency boundaries are not amendable in the manner proposed in the Constitution Amendment Bill. The respondents have opposed petition number E402 of 2020 on grounds of unjusticiability for want of ripeness, on the political question doctrine, on the principle of separation of powers, arguing that at the time this petition was filed, the Constitution Amendment Bill was pending before the legislature and there was no real dispute before the court. Secondly, that the people, in the exercise of their sovereign power, can provide for additional constituencies and further provide how the additional constituencies are to be allocated. In addition, that the people can amend the Constitution to change the structure, functions, and mandate of the IEBC. On these grounds, the respondents urge the court to exercise both constitutional avoidance and judicial restraint and decline to exercise jurisdiction. On public participation, the respondent's position is that public participation in respect of the proposed constitution amendment can only be properly considered as a continuum, starting from the publication of the proposals to the time of the passage of the amendments after a referendum, and hence the petitioner's claims on these issues are premature. To answer the questions presented to us as framed above, we have no choice but to look for answers from the historical backdrop of delimitation of constituencies. As we described above, our canons of constitutional interpretation require us to do so. We know from our soul as a nation, that the constituency as a unit of representation is at the heart of our electoral process. It goes to the root of the exercise of our democratic right to representation and to an aspect of the enjoyment of our social and socio-economic rights. This is because we see it as yet another unit for the quote-unquote distribution of development, or quote-unquote taking development to the people. This is evidenced by the fact that we have put in place the Constituencies Development Fund Act 2013, whose Section 4.1 we have reproduced in this judgment. As outlined in Part 4 of this judgment, the 2007 general elections heralded a dark chapter in the history of our nation. It led us as a nation into deep introspection towards settling the issues that had taken us to the brink of the precipice. As discussed earlier, as part of our never again resolve as a nation, 2 commissions were appointed to process our national trauma into fruitful governance structures. It was in this regard that the Independent Review Commission on General Elections, IREC, headed by South African Judge Johan Kriegler, was appointed on 13th March 2008 to inquire into all the aspects of the general elections held in Kenya on 27 December 2007. The Kriegler report concluded that there existed gross disparities in the voting populations and gross disparity in the sizes of Kenya's constituencies. Earlier, on 28 February 2008, President Mwai Kibaki for the government Party of National Unity, and Honorable Raila Odinga for the Orange Democratic Movement, acting together for Kenya, signed the agreement on the principles of partnership of the coalition government to address the long-term issues towards achieving a prosperous Kenya for all. The coalition government committed itself to the Kenya Vision 2030, in which, under the political pillar, the country's political governance system was to be transformed, including the rule of law and electoral and political processes. The vision was to cultivate generally competitive and issue-based politics, whose strategic themes include introducing laws and regulations covering political parties, enhancing the legal and regulatory framework covering the electoral process, and conducting civic education programs to widen knowledge and participation among citizens to achieve an informed and active citizenry. On the 12th of May 2009, the Interim Independent Boundaries Review Commission was appointed to exercise the powers conferred by Section 41(b)(2) of the former Constitution. The IIBRC presented its report on delimitation of constituencies and recommendation on local authority electoral units and administrative boundaries for districts and other units, dated 27th November 2010. The then President Mwai Kibaki, the then Prime Minister Honorable Raila Odinga, and the then Speaker of National Assembly Honorable Kenneth Marende. The IIBRC report noted that on the question of delimitation of electoral boundaries in Kenya, the Kriegler report had pointed out that the existence of gross disparities in the voting population of Kenya's constituencies had noted out the existence of disparities in the voting population of Kenya's constituencies. The IIBRC report had also noted that this state of affairs breached the fundamental equality principle of democracy, clearly articulated and enshrined in Section 42(3) of the then Constitution of Kenya, namely, one person, one vote. It was further noted that this long-standing discrimination in itself impaired the integrity of the electoral process, mainly, but not only, in relation to parliamentary elections. To that end, the Commission identified its underlying task, the correction of historical injustices and gerrymandering of the past in the electoral process, which highly contributed to the 2007 chaos as singled out by the Kriegler report. More specifically, the IIBRC was to undertake the functions as provided for under Section 41(c) of the former Constitution. This mainly included, and we have set out what the section said, the IIBRC also reported that it recognized from the beginning of its work that the process of delimitation of boundaries for electoral and administrative units was people-driven and required close consultations with the public, including key stakeholders. To enable it effectively carry out its work, the IIBRC identified 5 internationally accepted principles for delimitation of electoral units, which it sought to uphold throughout the delivery of its mandate in as far as possible within Kenya's circumstances, and especially the constitutional parameters for delimitation of electoral boundaries. These principles were listed in the report as follows: community of interest, also known as representativeness; equality of votes, also known as equality of voting strength; independent or impartial boundary delimitation authority, such as the IIBRC as established in Kenya's circumstances; transparency, implying that the delimitation process should be as transparent as possible, with the methodology and guidelines clearly established and publicized in advance; and non-discrimination, indicating that electoral boundaries should not be drawn in a manner that discriminates against any particular group. It is noteworthy that these principles are now enshrined in the Constitution of Kenya 2010 at Article 89, where it provides for the delimitation of electoral areas. With the promulgation of the Constitution of Kenya 2010, the IEBC was mandated by the 6th schedule at section 27 to continue functioning to carry out the first constituency boundaries review. In so doing, the IEBC was required to determine the boundaries of constituencies and wards using the criteria set in Article 89 of the Constitution of Kenya 2010. However, due to legal challenges, including the case of John Kimathi Maingi versus Andrew Ligale and 4 others, 2010 EKLR, where the High Court ruled that the IEBC did not fully discharge its mandate, the IEBC could not gazette its report. However, the IEBC report was adopted by Parliament, leading to the enactment of the IEBC Act in July 2011. The IEBC would undertake the finalization of the first electoral boundaries review, exercising the powers conferred by Articles 88 and 89 of the Constitution of Kenya 2010 and the IEBC Act. The IEBC was mandated to resolve all issues arising from the first review relating to the delimitation of boundaries of constituencies and wards. These included issues of new constituencies falling outside the population quota as provided for by Article 89(6) of the Constitution, but at the same time ensuring that such a process took into account the provisions of Article 89(7) of the B of the Constitution. The IEBC delimited the 290 constituencies that are now found at Article 89(1) of the Constitution. These are the constituencies that have determined the number of elected members of Parliament, of National Assembly, as per Article 97(1)(a) of the Constitution. With this history sharply in focus, we will now turn back to the Constitution Amendment Bill. It was argued by the respondents that the Constitution of Kenya provides a very clear procedure for Constitution Amendment under Article 257, and the Constitution Amendment Bill met the requirements of this provision. The respondents also argued that at the time of filing the petition number E402 of 2020, the Constitution Amendment Bill was pending before the county assemblies for consideration, hence there was no real issue for determination before this court. For this reason, the respondents urged the court to exercise judicial restraint. This is not the first time that a bill under consideration before the legislative bodies is being challenged before the court for want of constitutionality. Suffice it to say here that this court, in interpreting the Constitution under its authority donated by Article 165 of the Constitution, is mandated to give relief to both actual violations of the Constitution as well as threatened violations. Our decisional law has consistently held that the correct reading of Articles 22, 165 sub-Article 3D, and 258 of the Constitution yield the conclusion that a party does not have to wait until a right or fundamental freedom has been violated, or for a violation of the fundamental freedom, or for a violation of the fundamental freedom, or for a violation of the Constitution to occur. Let me say that again. I'm sorry, I think there's a typo somewhere. That it says a party does not have to wait until a right or fundamental freedom has been violated, or for a violation of the Constitution to occur before approaching the court. He has a right to do so if there is a threat of violation or contravention of the Constitution. This was the holding in the case of Coalition for Reform and Democracy Code and 2 others versus Republic. We have also cited, reproduced parts of the judgment in the Commission for the Implementation of the Constitution case, where the court addressed the same issue. In the present case, Mrima J was confronted with a preliminary objection raising substantially the same objections in petition E282 of 2020. In a ruling dated 30th November 2020, the learned judge cited the above case, that is the Coalition for Reform and Democracy court case in holding that the questions presented in the petition are justiciable and ripe for resolution by the court. We have no hesitation in extending that holding to the other 7 petitions in these consolidated petitions. For that reason, we decline the invitation to exercise judicial restraint or to apply the doctrine of constitutional avoidance to consider the merits of the questions presented in petition number 402 of 2020. We also find that neither does the doctrine of separation of powers bar this court from exercising jurisdiction under Article 165, Sub-Article 3D2 in the circumstances of this case. We agree with what was said in Republic versus the IEBC and others, ex parte Councillor Elliot Lidubui, and we have reproduced the part that we rely on in this judgment. The Honorable Attorney General argued in this matter that the court ought to decline to exercise jurisdiction because the petitioner had not exhausted the existing alternative avenues of redress. In the view of the Honorable Attorney General, the fact that the petitioners could persuade both houses and the Kenyan people to reject the Constitutional Amendment Bill is an existing alternative mechanism which they ought to pursue first before approaching the court. We respectfully disagree. This argument misapprehends the doctrine of exhaustion. It is true that our decisional law has consistently held that where a dispute resolution mechanism exists outside the courts, the same be exhausted before the jurisdiction of the courts is invoked. Courts ought to be a fora of last resort and not the first port of call the moment a storm brews. This was so stated in the Court of Appeal by the Court of Appeal in Geoffrey Mudinja Kabiru and 2 others versus Samuel Munga Henry, reported in 2015 EKLR. What is clear from that enunciation by the Court of Appeal is that the doctrine refers to dispute resolution mechanisms. A party is only debarred from approaching the court where a statute or policy has created a mechanism for determining a dispute related to the subject matter in question. In the present case, however, the Honorable Attorney General has not made the argument that any alternative dispute resolution mechanism has been created where the petitioners can plead their case. Instead, the Honorable Attorney General implies that the petitioners should take the political route to persuade members of the County Assembly, members of Parliament, and the Kenyan people at large in the event the questions go for referendum. The Honorable Attorney General implies that this is the existing alternative dispute resolution mechanism. However, this is not a dispute resolution mechanism within the meaning of the doctrine of exhaustion. For the doctrine to apply, there must exist a specific mechanism for resolution of declared disputes or controversy by a body specifically created or given the mandate to deal with such disputes or controversy. It is not envisaged that the political process can serve as such an alternative dispute resolution mechanism for purposes of the exhaustion doctrine. That forum is not capable of resolving any declared disputes or controversies. The political fora the Honorable Attorney General referred to are certainly available to all citizens to attempt to influence the political processes, but not to resolve any specific disputes or alleged violations of rights by specific individuals or alleged contraventions of the Constitution respecting any intended course of action by the political branches. We will now turn to the 2 substantive questions presented on the issue of apportionment and delimitation of constituencies as it relates to the Constitution Amendment Bill. The first issue is whether it is lawful for a Constitutional Amendment Bill to set a specific number of constituencies under Article 89(1) of the Constitution. For purposes of this part, we reproduce the whole of Article 89 of the Constitution in this part of the judgment. The first question the petitioner in 402 of 2020 asks is whether A constitutional amendment bill can increase or decrease the number of constituencies specifically created by Article 89(1) of the Constitution. Differently put, the question is whether Article 89(1) of the Constitution is part of the basic structure and whether it is an amendable clause of the Constitution given our definitions of the two concepts in Part 4 of this judgment. We think this is a question that can easily be answered given the text of the Constitution and the history of Article 89 of the Constitution given above. Both the text and the history of the article make it clear that Kenyans were very particular about the criteria of the delimitation and apportionment of constituencies. This was because the apportionment and distribution of electoral units has a bearing on both the right to representation, which is a political right, as well as the distribution of national economic resources, which is an economic right. The reason for this, as outlined above, is that a substantial amount of national resources distributed to the regions by the national government is done at the constituency level. Given this history, the text of the Constitution, we can easily conclude that whereas Kenyans were particular to entrench the process, procedures, timelines, criteria, and review process of the delimitation of electoral units, they were not so particular about the determination of the actual number of constituencies. Utilizing the canons of constitutional interpretation we have outlined in this judgment, we conclude that Article 89(1) of the Constitution, which provides for the exact number of constituencies, while being part of the basic structure of the Constitution, is not an eternity clause. It can be amended by duly following and perfecting the amendment procedures outlined in Articles 255 to 257 of the Constitution. This brings us to the second substantive question asked by the petitioner in Petition 402 of 2020. Is it lawful for a constitutional amendment bill to directly allocate and apportion the constituencies it creates without a delimitation exercise as set out in Article 89 of the Constitution? Section 1, subsection 1 of the second schedule of the Constitution Amendment Bill states as follows, and we have quoted it. Then Section 1(2) of the second schedule of the Constitution Amendment Bill proceeds to distribute the additional 70 constituencies among the counties as follows, and I'll read that section. Mombasa 3, Kwale 3, Kilifi 4, Mandera 1, Meru 2, Embu 1, Machakos 3, Makueni 1, Kirinyaga 1, Murang'a 1, Kiambu 6, Turkana 1, West Pokot 1, Trans Nzoia 2, Uasin Gishu 3, Nandi 1, Laikipia 1, Nakuru 5, Narok 3, Kajiado 3, Kericho 1, Bomet 2, Kakamega 2, Bungoma 3, Siaya 1, Kisumu 2, Nyamira 1, and Nairobi City 12. Then Section 1(3) of the second schedule proceeds to state as follows: the allocation of additional constituencies among the counties specified above shall A. prioritize the constituencies and are represented in the National Assembly on the basis of population quota, and B. be made in a manner that ensures the number of inhabitants in a constituency is as nearly possible to the population quota, and the emphasis there is ours. These provisions do four things. 1. They create 70 additional constituencies by dint of the Constitution Amendment Bill. 2. They direct the IEBC to determine boundaries and to delimit the 70 created constituencies to specific counties. 3. They stipulate the period within which the IEBC must determine and delimit the boundaries of the 70 created constituencies to 6 months from the commencement of the intended act. And 4. They stipulate to the IEBC the criteria to use in distributing and delimiting the newly created constituencies. These actions must be examined in light of Articles 88, 89, and 249 of the Constitution, the basic structure, and our history as outlined above. The IEBC is established by Article 88 of the Constitution with very specific roles. Among the specified roles is the delimitation of constituencies and wards. See Article 88(4)(c). This specific role is further elaborated in Article 89 of the Constitution, which we have reproduced herein above. The delimitation procedure is further set out and elaborated at Section 36 of the Act. We have set out Section 36 in the judgment. On the other hand, Article 249 sets out the objects, authority, and funding of the IEBC as an independent commission, and the IEBC is obligated to protect the sovereignty of the people, to secure the observance by all state organs of democratic values and principles, and to promote constitutionalism. Article 249(2) then provides that the IEBC as an independent commission is subject only to the Constitution and the law, and is independent and not subject to direction or control by any person or authority. Looking at the provisions of the Constitution and statutory law produced above, as well as the history we have outlined at the beginning of this part of the judgment, we can, at the outset, state authoritatively that the impugned sections of the Constitution Amendment Bill are unlawful and unconstitutional for the following reasons. First, they impermissibly direct the IEBC on the execution of its constitutional functions. Second, they purport to set a criteria for the delimitation and distribution of constituencies, which is at variance with that created by the Constitution at Article 89(5). Third, they ignore a key due process constitutional consideration in delimiting and distributing constituencies, namely the public participation requirement. Fourth, they impose timelines for the delimitation exercise, which are at variance with those in the Constitution. Fifth, they impermissibly take away the rights of individuals who are aggrieved by the delimitation decisions of the IEBC to seek judicial review of the decisions, of those decisions. And sixth, by tacking in the apportionment and delimitation of the 70 newly created constituencies in the second schedule using a preset criteria which is not within the constitutional standard enshrined in Article 89(2)(12). The new provisions have the effect of extratextually amending or suspending the intended impacts of Article 89 of the Constitution, which forms part of the basic structure of the Constitution and are therefore unamendable. We will briefly look at these reasons in turn. The first one, as the text of the Constitution makes clear, the IEBC is an independent commission. It is required to act independently and not to be subjected to the control or direction of any person or authority. Yet, the provisions in the Constitutional Amendment Bill on delimitation of constituencies explicitly direct IEBC on how to perform its functions. It directs the IEBC on what to do, how to do it, and when to do it with regard to the newly created constituencies. It requires no belabored analysis to conclude that this is an explicit subversion of the constitutional edict that IEBC shall not be directed on how to perform its functions. Second, the Constitutional Amendment Bill not only unlawfully takes over the functions of IEBC, but it also allocates constituencies in violation of the constitutional principles set out in Article 89, which IEBC is obliged to adhere to in executing its mandate. The Constitution at Article 89(5), 89(6), 89(7) clearly sets out that it is the IEBC to conduct the process of delimitation and also sets the criteria to be used. We have reproduced the procedure and criteria that the IEBC is obligated to use above. Yet, the Constitution Amendment Bill directs the IEBC to determine the boundaries of additional constituencies by using the criteria provided for in Articles 81D and 87.7. This is Section 1.1 of the second schedule to the Constitution Amendment Bill. On the other hand, Section 1.3 of the second schedule provides the IEBC to prioritize the constituencies and are represented in the National Assembly on the basis of population quota and to make delimitation decisions in a manner that ensures the number of inhabitants in a constituency is as nearly as possible to the population quota. Article 81D provides that the electoral system shall comply with the principle that universal suffrage based on the aspirations for fair representation and equality of vote. And section, it's about, there's a typo there. So it's about electoral disputes, and it is not related to Article 89, Article 89 of the Constitution. And then Article 87 does not have subarticle 7. So there's a problem with even the law that is cited under which IEBC is being directed to carry out its functions. So what emerges from the above is that the Constitution Amendment Bill sets its own criteria on delimitation by citing Article 81D. This is a criteria and known as a delimitation consideration in the Constitution. It refers to an existing criterion in the form of Article 87.7. Reduces all the consideration listed in Article 89.5, 6, and 7 to a single one, namely the population quota, as the basis for the delimitation decisions with respect to the 70 additional constituencies. By doing these three things, the Constitution Amendment Bill seeks to short-circuit Article 89 by apportioning the newly created constituencies to specific counties and then directing IEBC, in essence, to delimit boundaries based on a single criterion. This is contradistinguished to the several criteria specifically set out in the Constitution at Articles 89.5, 6, and 7. This renders the proposed amendments in this regard irregular, illegal, and unconstitutional. The third reason the provisions on apportionment and delimitation of the additional constituencies are unconstitutional is that they purport to create a process of delimitation which ignores an irreducible constitutional consideration, public participation, stakeholder engagement, and consultation of interested parties. There is no doubt that the Constitution requires IEBC to conduct public participation, consult interested parties, and engage all affected stakeholders when carrying out its delimitation mandate. Article 89.7a is explicit in requiring the IEBC to consult all interested parties. We have gone on to reproduce Section 36.4 to 36.11 of the IEBC Act, which deals with that process. These provisions are clear on the requirement of public participation and stakeholder engagement in the delimitation exercise. Indeed, they require public participation and stakeholder engagement not only during the process of delimitation itself, but even after the IEBC has published its preliminary report and before publishing the final one. This robust requirement of public participation and stakeholder engagement only accentuates the requirements in Article 10 of the Constitution. Despite these clear requirements in the Constitution and the statutory law, the Constitution Amendment Bill ignores the requirements of public participation and stakeholder engagement. This is in conflict with Article 89.7, the national values and principles in Article 10.2, and Section 36 of the IEBC Act. This too renders the Constitution Amendment Bill unconstitutional. The fourth reason the Constitution Amendment Bill runs afoul of the Constitution is that it stipulates a timeline for the delimitation which is in conflict with the one created in the Constitution. Section 1.1 requires the IEBC to determine the boundaries of the additional 70 constituencies within 6 months of the commencement of the intended act. However, Article 89.2 gives the timelines for review of boundaries. Among other things, it requires the IEBC to review boundaries of constituencies at intervals of not less than 8 or more than 12 years. But Article 89.4 requires IEBC to complete the review of boundaries not more than 12 months to the next general elections if the new boundaries will take effect for purposes of those general elections. The present Constitution Amendment Bill, however, at Section 1.6 of the second schedule, purports to suspend the operation of Article 89.4 of the Constitution by providing that, quote, the requirement in Article 89.4 does not apply to the review of boundaries for the additional constituencies preceding the first general elections from the commencement date of the intended act. What the explicit terms of these provisions propose to do is to permit the IEBC to begin and complete the delimitation exercise outside the timelines expressly provided in the Constitution. It only requires the IEBC to do the review within 6 months from the date of commencement of the Act, even if those 6 months come within the 12 months of the general elections. These provisions are plainly unconstitutional because they impermissibly purport to suspend the operation of a constitutional provision which, given the history we have provided above and the text and context of the Constitution, forms the basic structure of the Constitution. Indeed, we plainly find that the provisions of Article 89.2 to 89.12 are eternity clauses and unamendable. It is for this reason that we have also concluded that the procedure and process that the promoters of the Constitutional Amendment Bill have used to create, apportion, and delimit the proposed 70 new constituencies amounts to an impermissible extra-textual amendment to the Constitution by stealth. We say it is an attempt to amend the Constitution by stealth because it has the effect of suspending the operation of Article 89 without textually amending it. The implications of such a scheme, if allowed, are at least twofold. First, it creates a constitutional loophole through which the promoters can amend the basic structure of the Constitution without triggering the primary constituent power. I think I need to say that again. First, it creates a constitutional loophole through which the promoters can amend the basic structure of the Constitution without triggering the primary constituent power. Second, such a scheme creates a constitutional hatch through which future promoters of constitutional amendments can sneak in fundamental changes to the governing charter of the nation for ephemeral political convenience and without following the due process of the law. Lastly, the provisions of the Constitutional Amendment Bill take away, in violation of the Constitution, the rights of individuals who may be aggrieved by the delimitation decisions of the IEBC to seek judicial review of those decisions. That right of judicial review is enshrined in Article 89.10. The provisions of the Constitutional Amendment Bill purport to take away this constitutionally granted right without a substitute. Again, in essence, what the promoters of the Constitutional Amendment Bill purport to do is to suspend the operation of Article 89.10 of the Constitution by stealth. The value of Article 89.10 can be seen at work in the decision in John Kimathi Maingi versus Andrew Ligale and 4 others, where the first attempt at delimiting under this Constitution done by the IRBC was declared unconstitutional after a court challenge. Now, the next part of the judgment, we are looking at the readiness and propriety of IEBC to conduct the proposed referendum. The first issue to deal with here is the quorum of the IEBC. The petitioner, in petition number 416 of 2020, argued that the IEBC does not have quorum to conduct business of policy nature, including verifying signatures and holding a referendum. The respondents, however, contended that the IEBC is properly constituted to conduct its business. In their view, verification of signatures and the conduct of elections or referenda is not a policy decision requiring quorum, but a constitutional mandate under Article 88(4) of the Constitution. They also argued that the issue of composition and quorum of the IEBC was decided in Isaiah Biwott Kangoni versus IEBC and another reported in 2018 EKLR and is therefore res judicata. Both the petitioner and the respondents were in agreement that the IEBC is not fully constituted and that indeed there are vacancies that are yet to be filled. The point of divergence, however, was on whether there was quorum for it to conduct business on policy matters. Whereas the petitioner argued that the verification of signatures and conducting referendum are policy issues requiring quorum of the IEBC, the respondents held the opposite view. In the respondents' view, the IEBC meets the minimum constitutional threshold of 3 commissioners and therefore it can conduct its business. Article 251 of the Constitution provides for the composition of Chapter 15 commissions. Each commission should have at least 3 and not more than 9 commissioners. Section 5(1) of the IEBC Act provides that IEBC shall consist of the chairperson and 6 other commissioners. Section 8 provides that the conduct of the IEBC's business should be in accordance with the second schedule to the Act. Paragraph 5 of the second schedule, which is material to this issue, provides that the quorum for the conduct of business at a meeting of the IEBC is at least 5 members. Sometime in 2017, after the general elections of that year, several commissioners resigned, leaving only the chairperson and 2 commissioners in the office. In 2018, a petition was filed seeking the court's determination, on whether the IEBC composition was unconstitutional and illegal. This was the case of Isaiah Biwott Kangoni, quoted above. The petitioner in that case failed to persuade the court that the IEBC was unconstitutional and illegal by dint of having only a chairperson and 2 commissioners. It is on this basis, the basis of this decision, that the respondents argued in the present case that the current challenge to the composition of the IEBC is res judicata. We have already defined the doctrine of res judicata in another part of this judgment, as it applies in Kenya. As earlier discussed, to successfully raise the defense of res judicata, the issues in dispute in the previous litigation suit must have been between the same parties as those in the present suit. They must have been directly or substantially in issue, as was the case before, and must have been conclusively determined by a court of competent jurisdiction. We have read the decision of the court in the Isaiah Biwott Kangoni case. In that decision, the petition sought 4 principal orders. 1, a declaration that the composition of the IEBC was illegal and unconstitutional as a result of the resignation of 4 of its commissioners, and therefore it lacked quorum to conduct or carry out its business. 2, a declaration that the IEBC's composition was illegal and unconstitutional as a result of the resignation of its 4 commissioners, and therefore it could not hold or supervise any elections or by-elections that were due for 17th August 2018. 3, a declaration that the IEBC's composition was illegal and unconstitutional, and as a result of the resignation of 4 of its commissioners, and therefore any purported by-elections it was to hold would be null and void. And 4, an order to the effect that all administrative actions taken by the IEBC with regard to the preparations for the intended by-elections were illegal, unlawful, and null and void, and contrary to the provisions of Article 47 of the Constitution. The court, Ompwani J, considered the petition but was not persuaded that the IEBC's composition was unconstitutional and illegal. The challenge in that petition was on 2 fronts: failure to comply with the 2/3 gender principle and quorum based on the number of commissioners. On the first issue of gender, the learned judge concluded that prior to the resignations The IEBC composition complied with the requirement of the 2/3 gender principle. The court's finding was that occurrence of a vacancy in the IEBC did not invalidate the composition of the commission, but reduced the number of commissioners, with the result that it limited the IEBC's operations with respect to raising the quorum required for meetings, especially when dealing with policy issues. The court concluded that the IEBC could conduct by-elections because this did not require quorum to decide. This is the decision that the respondents relied on to argue that the issue of composition of the IEBC has been determined and was therefore res judicata. We have considered the arguments by parties and read the decision. The prayers that were sought in that decision were declarations that the composition of the IEBC was illegal and unconstitutional following the resignation of majority of the commissioners. The court did not agree that there were resignations or vacancies. The court also found that resignations, if any, only reduced the number of commissioners so as to affect quorum in the event that IEBC was conducting business on policy matters. In the court's view, conducting by-elections was not affected by lack of quorum, since the court formed the view that conducting by-elections did not involve the making of policy decisions. In the present petition, the petitioner's concern is that IEBC is not properly constituted for purposes of verifying signatures and does not have quorum to conduct a referendum. He is not challenging the constitutionality or legality of the existence of IEBC as a commission under Article 251 of the Constitution. In that regard, we are of the considered view that the issue before this court was not conclusively determined in the case of Isaiah Biwott Kangoni, to render the question of the IEBC's quorum as raised in this petition res judicata. We begin by noting that while the holding in Isaiah Biwott Kangoni case is that IEBC only needs the quorum required under paragraph 5 of the second schedule to the IEBC Act in order to make policy decisions, that section does not contain any such qualification. The paragraph reads as follows, quote, "The quorum for the conduct of business at a meeting of the Commission shall be at least 5 members of the Commission." In our view, the statute is clear. The IEBC requires 5 commissioners in order to conduct any business. The statute does not distinguish between policy and other business. We therefore respectively depart from the holding in the Isaiah Biwott Kangoni case that the IEBC can conduct business other than making policy decisions when its membership is below the minimum 5 stipulated in paragraph 5 of the second schedule. The statute requires that IEBC to have the minimum of 5 commissioners in order to conduct any business, period. In any event, verifying the signatures and determining whether the promoters of the Constitution Amendment Bill met constitutional requirements under Article 257(4) is a threshold question and therefore would be, by any definition of the word, a policy issue that would require the IEBC as a commission to determine. Such a serious constitutional question, being a policy issue, could not be determined by a committee of the Commission. Only where the IEBC had quorum could it make such a fundamental determination. Similarly, verification of signatures and determination of whether or not they met constitutional requirements was also a question to be determined by the IEBC as a business of the Commission, with the necessary quorum and after full and critical considerations. Hence, even under the holding in Isaiah Biwott Kangoni case, the verification of signatures and the determination of whether the constitutional threshold had been met for purposes of Article 257(4) of the Constitution are definitionally policy considerations which required quorum under paragraph 5 of the second schedule of the IEBC Act. We say so because one of the IEBC's key mandates under Article 88(4) is to conduct referenda. This mandate is also emphasized in Section 4 of the IEBC Act. Section 8 of the Act places composition of the IEBC at 7, the chairperson and 6 other commissioners. On the other hand, paragraph 5 of the second schedule to the Act puts the quorum at 5 commissioners. The fact that IEBC did not have the quorum of 5 members when it conducted verification of signatures and determined that the BBI Secretariat had met the constitutional threshold under Article 257(4) of the Constitution to move the process to the next stage is not in doubt. Equally, not in doubt is the fact that the statute requires that quorum. This statutory provision was not inserted for cosmetic purposes. It underlines the critical constitutional roles placed on the shoulders of the IEBC. If the Constitution placed the threshold of voters to support a constitutional amendment bill at 1 million to be verified by the IEBC, such a high threshold could not be determined by an organ that did not have the statutory quorum. The Constitution placed the minimum number of commissioners of independent commissions at 3 and highest at 9. Parliament, while appreciating the important mandate the IEBC discharged, picked a high number of 7 commissioners to constitute it and placed the quorum at 5 members. Taking into account how serious and consequential amendments to the Constitution are, all decisions connected therewith, including the verification of signatures in support of a popular initiative and the determination whether or not the constitutional threshold and Article 257(4) has been met, we conclude that these decisions could only be taken by a quorate IEBC. We also conclude that the IEBC Act categorically places the quorum of IEBC for purposes of transacting business at 5 commissioners. Finally, we conclude that the IEBC did not have this quorum at the time it made the consequential decisions related to the Constitutional Amendment Bill. It therefore follows that all the decisions so made by the IEBC in relation to the proposed constitutional amendment, and in particular to the Constitutional Amendment Bill, were invalid, null and void for lack of quorum. And I hand over to the presiding judge.
Thank you, Judge. And now for those of you who are on tenterhooks to finish our judgment before you can have your dinner, I would like to assure you that we are very quickly militating towards that direction. But first, I will turn to the question of the legal regulatory framework for the verification of voter support for a popular initiative. It's another issue related to the IEBC. The main issue raised in petition number E2 of 2021 is whether there is a legal or regulatory framework to regulate the verification and other processes required under Article 257(4) and 5 of the Constitution. A related question is whether, if such a legal or regulatory framework is required, one in fact exists. Finally, the petition raises the issue whether the IEBC has the required infrastructure for purposes of conducting the verification mandate imposed on it by Article 257(4) of the Constitution. The respondents have urged the court to find that the issues in this petition, these 3 issues, as framed above, were settled in 2 earlier cases, that is the Titus Alila case, which we've cited before, and the ex parte Kenda Muriuki case, which you've also cited before. In the interest of everybody having their dinner on time, I will not go over our reasoning on those two decisions, except to say that we concluded that those 2 decisions have not covered the 3 issues as framed in this petition. The petitioner argues that the IEBC cannot constitutionally conduct verification under Article 257(4) of the Constitution in the absence of a regulatory framework. The petitioner further argues that no such regulatory framework exists. The petitioner points out that whereas Parliament has attempted to pass legislation on Article 257 of the Constitution, it has not been enacted yet. There are 2 related bills still pending in Parliament. Hence, the petitioner argues that even Parliament is aware that there is a lacuna. The petitioner further argues that the IEBC is also aware of the lacuna and has attempted to address it through its administrative procedures for the verification of signatures in support of constitutional amendment referendum, which I will call hereafter administrative procedures, first approved on the 15th April 2019 and revised in 2020. However, the petitioner contests the legality of the administrative procedures on 2 counts. First, the petitioner argues that the administrative procedures were developed without public participation. Second, the petitioner argues that the administrative procedures are statutory instruments which could not become effective before parliamentary approval. Consequently, the petitioner argues that IEBC has no legal or regulatory framework to use in the verification of signatures for purposes of referendum and Article 257(4) of the Constitution. The petitioner requests for certain reliefs flowing from these arguments, including a declaration that the existing administrative procedures are invalid and could therefore not be used to verify signatures in support of the Constitution Amendment Bill. On the other hand, the IEBC's position is that a textual reading of Article 257(4) of the Constitution yields the conclusion that the IEBC is only required to verify that a popular initiative to amend the Constitution is supported by 1 million registered voters and not the signatures. Counsel for IEBC indeed submitted that it was not the mandate of the IEBC to verify whether or not the signatures were forgeries or obtained without consent. Its only role, insisted counsel for IEBC, is to confirm that the popular initiative bill is supported by 1 million voters. Consequently, the IEBC maintained that it requires no more legal or regulatory framework than the constitutional provisions in Article 257(4) of the Constitution. Counsel for the IEBC described the provisions of Article 257 of the Constitution as self-executing, which we understand to mean that no further legislation or regulations are necessary to efficaciously implement the constitutional provisions, including the verification provisions. In any event, counsel for the IEBC argued if any further legislation or regulations were needed to implement Article 257 of the Constitution, then they were already in existence in the form of the Constitution, in the form of Sections 49 to 55 of the Elections Act and the IEBC Act. Further, counsel argued that the IEBC developed, under their legal mandate, the administrative procedures, which includes a form to capture information which corresponds with information in the IEBC's database. Hence, counsel for the IEBC was of the view that the lack of legislative framework does not stop the IEBC from carrying out its mandate. To address the three related issues framed for this petition number 2 of 2021, it appears to us that the starting point is to determine what the mandate and role of the IEBC is under Article 257(4) of the Constitution. In particular, the question for determination is whether IEBC's role includes verifying of signatures or whether the role only ends at the proverbial bean counting. That is, mere technocratic ascertainment that a promoter of a popular initiative has delivered 1 million voters to the IEBC. If the IEBC's role includes verification of signatures and not mere ascertainment of numbers of registered voters whose signatures accompany the popular initiative bill, it would follow that the IEBC would need some legal or regulatory framework to guide it in its operations. On the other hand, if the IEBC's role is the venial administrative task of ascertaining numbers, then perchance no further legal or regulatory framework would be required. In order to answer this question, we turn to the affidavit of Dennis Wawero, which was sworn on 5th February 2021. The affidavit is sworn on behalf of the BBI National Secretariat, one of the respondents in this petition. Mr. Wawero has annexed a document entitled The Findings of the Commission on the Process of the Verification of Signatures for the Proposed Amendment to the Constitution of Kenya 2010 through a Popular Initiative or Core Kenya Initiative, dated 22nd March 2016. Hereinafter, I will simply call this report the IEBC Verification Report. This was the report of the then chairperson of the IEBC on the verification process carried out by the IEBC with respect to the Constitutional Amendment Initiative known as Okoa Kenya Initiative in 2016. The IEBC Verification Report explicitly acknowledged IEBC's role under Article 257(1) and 257(4) of the Constitution, stating at paragraph 8 of the document that The operative phrase as far as the mandate of the IEBC under Article 257(4) is concerned is to verify that the initiative is supported by at least 1 million signatures of registered voters. The questions the Commission posed were, what is to verify? How do you verify that a person is a registered voter? How do you go about the entire verification process? This is a direct quote from the IEBC report. Applying the definition of verify from the Black's Law Dictionary, this same report by the IEBC states as follows, and I quote it: "It appears, therefore, to verify is not to casually look at information presented to you, but to take steps that will allow one to affirm, even under oath, the correctness, accuracy, truthfulness, or exactness of the information." On whether the Commission was to verify the authenticity of the signatures only, or what the supporters, or that the supporters are registered voters, that same report by the IEBC stated, the Commission's view is that the verification entails confirming that the initiative is supported by registered voters as evidenced by their signatures. After reviewing practices in other jurisdictions, it was clear to the IEBC that a person mandated to verify signatures must satisfy herself or himself that the said signatures belong to the persons whose names appear against them. Therefore, in 2016, with respect to the Okoa Kenya initiative, the popular initiative to amend the first popular initiative to amend the Constitution of Kenya 2010, the IEBC determined that to accomplish its mandate, it was required to carry out the verification of signatures and the verification that the supporters of the initiatives were registered voters. It determined that the proper sequence to achieve this was, in their own words, first, to confirm that the people supporting the initiative were registered voters, and second, to move to the second step of ascertaining the authenticity of the supporters' signatures. At paragraph 13 of the IEBC verification report, it states, in the case of Article 257(4) of the Constitution of Kenya, it would follow that the Commission has to verify that at least 1 million registered voters supported the initiative. Once the Commission is satisfied that 1 million registered voters support the initiative, it would then proceed to the next step of verifying that the signatures appended thereto are valid signatures of the registered voters. This is the process that the Commission followed in the Okoa Kenya initiative. Again, those are the words of the IEBC itself. In the case of Okoa Kenya initiative, as reported in the IEBC verification report, once the IEBC received the draft bill and the booklets of signatures, it embarked on the first step of verifying that the signatories were registered voters. However, when the number of registered voters fell below the 1 million mark after the first stage of the verification process, the IEBC, in its own words, did not consider it prudent to go to the next step of verifying the authenticity of the signatures of the registered voters, either by sampling method or otherwise. End of quote. Given this analysis of how IEBC handled the Okoa Kenya initiative, given in a sure-footed clarity by IEBC itself, and in its own words, etched in its own report, there is no doubt that the IEBC understands that its mandate and role and Article 257(4) of the Constitution includes a two-step process of, first, ascertaining the numbers of registered voters in support of a popular initiative to amend the Constitution, and second, verifying the authenticity of the signatures of the registered voters claimed to be in support of the popular initiative. It is, therefore, plainly startling that in the present petition, the IEBC has taken the clearly disingenuous position that its role is limited to merely ascertaining the numbers of registered voters in support of the popular initiative. This position is belied by its own report analyzed above. It is also belied by the text and spirit of the Constitution. As the IEBC verification report plainly acknowledged, the only reasonable meaning of the term verify, as used in Article 257(4) of the Constitution, includes both the ascertainment of the numbers and confirming the authenticity of the signatures submitted. If the importance of the above two-step process of verification of signatures and Article 257(4) of the Constitution is not sufficiently clear yet, a comparative analysis of voter verification for purposes of general elections will clarify it further. We've done that whole comparative analysis in the next part of our judgment, which I will not reproduce here, but I will reproduce the conclusion to that comparative analysis. The provisions of the Elections Act respecting voter verification demonstrate that IEBC determined that it was necessary to carry out a verification process for voter registration in the case of elections. The rules provide the time frames within which the voter verification is to be done and the actual process to be followed. They require, among other things, a voter who seeks verification to appear personally before a registration officer to verify the information held in the register. This comparative analysis demonstrates what the law requires IEBC to do in the case of voter verification for purposes of elections. There is no doubt that the IEBC takes its role in voter registration as more than a ceremonial exercise. The IEBC has established substantive standards and procedures to ensure the integrity of voter registration and verification regarding elections. If the IEBC is so scrupulous in carrying out its role in voter verification for elections purposes, it follows that the same standard at the very least should apply in the case of verification of signatures for purposes of constitutional amendments through popular initiative and Article 257(4). The above analysis establishes that the IEBC's role under Article 257(4) involved both the ascertainment of numbers of registered voters in support of a popular initiative to amend the Constitution, as well as verification of the authenticity of those signatures. The question that arises then is whether the IEBC has any legal or regulatory framework to achieve its mandate under Article 257(4). If the IEBC has a regulatory framework, namely the Elections Registration of Voters Regulations 2012 for voter verification for purposes of elections, it follows that the IEBC needs a regulatory framework for signature verification under Article 257(4) of the Constitution. Does the IEBC have such a regulatory framework for signature verification for purposes of Article 257(4)? The IEBC argues that the existing statutory framework is sufficient regulatory framework, and further that if it is not sufficient, the administrative procedures adequately cover the signature verification process. As analyzed above, the existing statutory framework is not sufficient for verification of signatures under Article 257(4) of the Constitution. Indeed, it is instructive that the Constitution Amendment Initiative that came after the Okoa Kenya Initiative, namely the Punguza Mzigo Initiative, the IEBC noted that there were, and I quote, no statutory procedures or timelines for the verification of supporters of constitutional amendment drives through popular initiative, end of quote. To fill in the gap, the IEBC developed administrative procedures approved on the 15th of April 2019. The question that arises then is whether the administrative procedures are lawful, and if so, whether they adequately serve the role of providing the required regulatory framework. The petitioner has urged us to declare the administrative procedures invalid for lack of public participation. The IEBC did not contest the fact that the administrative procedures were developed without public participation as required under Article 10 of the Constitution. For that reason alone, we would have no difficulty in adjudging the administrative procedures invalid. The petitioner also argued that the administrative procedures are invalid because they are statutory instruments and they have not been subjected to parliamentary approval as required under Sections 10 and 11 of the Statutory Instrument Act. Other than weakly argue that the administrative procedures are not statutory instruments, the IEBC has not seriously contested this argument. It requires no belabored analysis to conclude that the administrative procedures are statutory instruments, as that term is defined in Section 2 of the Statutory Instruments Act. Moreover, the administrative procedures were not gazetted as required by Section 22 of the same Act. Consequently, the administrative procedures are invalid both because of lack of public participation as well as the failure to comply with the provisions of the Statutory Instruments Act. Even if the administrative procedures survive this public participation and Statutory Instruments Act scrutiny, we would still find them invalid for purposes of providing the regulatory framework required under Article 257(4) for two other reasons. First, the administrative procedures were developed and revised without the requisite quorum under Section 8 as read together with the second schedule to the IEBC Act, as we have said above in this judgment. Second, a perusal of the administrative procedures reveals the obvious point that they do not have provisions or procedures for the authentication of signatures, which we have found is a necessary step in the verification exercise required under Article 257(4) of the Constitution. In addition, even if the administrative procedures had been valid, there is clear evidence that the IEBC did not comply with them. For instance, the IEBC published the list on its website on Thursday, 21st January 2021. Members of the public had up to Monday, 25th January 2021 to read the list and raise any issues they had with the list. It is noteworthy that the time period given for information and verification fell short of the time the IEBC's administrative of the time in the IEBC's administrative procedures. The administrative procedures provided for a 2-week period, while the IEBC gave only 5 days, both days inclusive and including the weekend. In view of the foregoing analysis, we conclude the following. First, a legal or regulatory framework for the verification of signatures under Article 257(4) of the Constitution was required. Second, the legal or regulatory framework required does not exist, and the convergence of existing statutes does not adequately form the requisite regulatory framework required under Article 257(4) of the Constitution. Third, the administrative procedures developed by the IEBC are invalid for the following reasons. One, they were developed without public participation as required under Article 10 of the Constitution. Two, they are in violation of the Statutory Instruments Act for want of parliamentary approval and for want of publication as discussed. And three, they were developed without quorum. Fourth, even if the administrative procedures had been valid, in the present case, the IEBC violated them. Next, we'll briefly consider the requirement for nationwide voter registration before any proposed referendum. The petitioner in petition number E416 of 2020 argued that every person has a right to make political choices and voter registration should supersede constitutional amendment process through a referendum. In his view, the IEBC cannot conduct a referendum before conducting nationwide voter registration. The IEBC contended that no one will be disenfranchised if the proposed referendum was held. According to the IEBC, voter registration did not stop in 2017. The IEBC maintained that in fulfillment of its obligations under the Constitution and the law, it undertakes continuous voter registration and updating of registered voters, which ended just before the Kibra by-elections in 2018 with 108,000 more registered voters. Article 38 of the Constitution guarantees every citizen political rights, including the right to free, fair, and regular elections based on universal suffrage and the free expression of the will of the elector. Every adult citizen has the right to be registered as a voter without unreasonable restriction and to vote in an election or referendum. Article 88 establishes the IEBC, while sub-article 4 of that article confers on it the mandate to conduct referenda and elections, conduct continuous voter registration, and regular revision of the voters' roll. This role is also found in the IEBC Act. Section 4 of that Act requires continuous registration of voters and revision of voters' roll. Similarly, Section 5 of the Election Act requires the IEBC to carry out voter registration and revision of the register of voters at all times except for a stipulated time just before the elections. These requirements are aimed at enabling citizens not only exercise but also realize the political rights guaranteed under the Constitution. The IEBC is under both a constitutional and statutory obligation to register voters and revise voters' registers at all times. The IEBC did not demonstrate to this court, in answer to the petitioner's claims, that it had conducted continuous voter registration, and if so, when voter registration was last conducted. It only stated, without any evidence, that it conducts continuous voter registration at constituency headquarters. We begin by noting that every single day, citizens attain the voting age. These new citizens have a right to be registered as voters and to participate in any proposed referendum. There was no evidence placed before this court that the IEBC has been discharging its constitutional and statutory obligations to enable citizens who have recently attained the voting age to register as voters. The IEBC also stated that the last time the voter register was revised was just before the Kibra by-election. This was a confirmation that it was not discharging its constitutional and statutory mandate to continuously register voters and review the register of voters. There was also no evidence that the IEBC had sensitized citizens that there was continuous voter registration. Holding a referendum without voter registration, updating the voters' register, and carrying out voter education would particularly disenfranchise citizens who had attained voting age but had not been given an opportunity to register as voters, thus violating their constitutional right to vote and make political choices. To register and vote is a right under the Bill of Rights. Article 20 of the Constitution is clear that the Bill of Rights applies to all law and binds all state organs and all persons, and every person is to enjoy these rights to the greatest extent consistent with the nature of the right or fundamental freedom. In this premise, Article 21 of the Constitution states that it is a fundamental duty of the state and every state organ, including the IEBC, to observe, respect, protect, promote, and fulfill the rights and fundamental freedoms in the Bill of Rights. We are persuaded, and we agree with the petitioner, that holding a referendum without first conducting voter registration would violate the very essence of the rights of a class of citizens who have not been given the opportunity to register and vote in deciding their destiny. Next, I will turn to the question that addresses whether conducting the referendum in the current prevailing circumstances of COVID-19 pandemic violates Article 43 rights of the Constitution. The petitioner in petition E416 of 2020 argued that continuing the constitutional amendment process, and in particular holding the referendum, will violate Article 43(1)A of the Constitution. It is this petitioner's arguments that the country, and indeed the world, is going through an unprecedented COVID-19 pandemic, which requires resources to combat. He argued that continuing with the constitutional amendment process will not only lead to the spread of the disease, but will also use much-needed resources for the referendum, thus deny the people realization of their right to the highest attainable standard of health guaranteed under Article 43(1)A of the Constitution. Honorable Raila Odinga, the Honorable Attorney General, the BBI Steering Committee, the National Assembly, the Senate, and IEBC were all united in denying this petitioner's claim. They maintained that the petitioner did not specifically plead and adduce evidence to support his arguments, and therefore the prayer should be denied. Article 43 of the Constitution guarantees every person the right to the highest attainable standard of health, which includes the right to health care services and reproductive health. At sub-article 3, it obligates the state to provide appropriate social security to persons who are unable to support themselves and their dependents. The right to health is not the same as the right to be healthy. The right to health means the right to enjoy a variety of goods, services, and conditions that are necessary to one's well-being. It is usually based on government's programs and goals that are realized for a long-term basis, usually dependent on availability of resources. From the constitutional standpoint, a country's difficult financial situation will not absolve it from taking key steps towards realization of this right for its citizens. The argument put forward by the petitioner, as we understand it, is that conducting a referendum now will provide an environment for the spread of the coronavirus, and therefore this court should stop the government from conducting such a referendum until the pandemic is over. He also argues that the resources that are to be used for the referendum should be channeled towards fighting the pandemic. We have anxiously considered the argument by the petitioner and those by the respondents. The issue raised by the petitioner, though novel, was not properly supported by sufficient evidence. Without such evidence to support the alleged threatened violations of the right to health, we are unable to make the findings the petitioner craves. We find it necessary to remind the petitioner and other public-spirited litigants who are keen to enforce socio-economic rights enshrined in Article 43 of the Constitution what this court, differently constituted, stated in William Ramogi and 3 others versus the Attorney General. We must emphasize, I'm quoting that court, the importance of adherence to the rules of evidence, both in terms of presentation, authenticity and foundation, and quality of evidence, that is credibility and probative value required to establish violations of fundamental rights and freedoms, especially in public interest or strategic litigation. The rules of evidence apply with equal force to this species of litigation as they do in run-of-the-mill litigation. This is especially true for cases where claimed violations are most appropriately proved by empirical evidence. Such evidence and data are often generated by experts and must be presented in adherence with the rules on presentation of expert evidence. Of course, reliance on empirical data does not detract from the need in appropriate cases to present direct evidence of the lived realities of the affected people on whose behalf the public interest litigation has been filed. We need not say more on this issue. The last issue we were asked to address in these consolidated petitions before we make our conclusions is on the alleged parliamentary infirmity arising from the Chief Justice's advisory for the dissolution of Parliament. The petitioner in E416 made the argument that this court should compel the President to dissolve the National Assembly and Senate following the advice of the Chief Justice dated 21st of September 2020, and further find that the two houses cannot receive and act on the BBI's constitutional amendment bill as they stand to be dissolved as advised by the Chief Justice under Article 261(7) of the Constitution. The issue of whether or not the President should dissolve the National Assembly and the Senate is live in Milimani High Court Petition number 302 of 2020, and the parties are Third Way Alliance for the Speaker of the National Assembly and another, which has been consolidated with Judicial Review Case number 1108 of 2020, as well as petition number E291 of 2020 and E300 of 2020. All those are currently pending before another bench of this court. The prayers the petitioner seeks in prayers H and I in their petition E416 of 2020 are subject in those consolidated petitions. In that regard, the petitioner may apply to join those petitions and urge its reliefs jointly with the petitioners in those petitions. We decline the invitation to deal with these issues in these consolidated petitions. And now, Council, ladies and gentlemen, Kenyans who are listening, this is the time to sit up. We are going to read our conclusions and findings. For those of you who are interested in getting what they call the plain English version of, or the summary of the decision, when you finally receive this long judgment later tonight, you can please go straight to paragraph 743, which I will now read, because it summarizes all our findings. And thereafter, I will read the orders that we have made. Having considered all the issues before us in these consolidated petitions, we have made inter alia the following conclusions. 1, the text, structure, history, and context of the Constitution of Kenya 2010, all read and interpreted using the canon of interpretive principles decreed by our Constitution, yield the conclusion that the basic structure doctrine is applicable in Kenya. 2, as applied in Kenya, the basic structure doctrine protects certain fundamental aspects of the Kenyan Constitution from amendment through the use of either secondary constituent power or constituted power. 3, the essential features of the Constitution forming the basic structure can only be altered or modified by the people using their sovereign primary constituent power and not merely through a referendum. 4, from a holistic reading of the Constitution, its history, and the context of the making of the Constitution, the basic structure of the Constitution consists of the foundational structure of the Constitution as provided in the preamble, the 18 chapters, and the 6 schedules of the Constitution. It also includes the specific substantive areas Kenyans thought were important enough to pronounce themselves through constitutional entrenchment, including the provisions on land and environment, leadership and integrity, public finance, and national security. 5, the basic structure doctrine protects the core edifice, foundational structure and values of the Constitution, but leaves open certain provisions of the Constitution as amendable through the procedures outlined in Articles 255, 256, and 257 of the Constitution, in as long as they do not change the basic structure. 6, there are certain provisions in the Constitution which are insulated from any amendment at all because they are deemed to express categorical core values. These provisions are, therefore, unamendable and cannot be changed through the exercise of secondary constituent power or constituted power. 7, the sovereign primary constituent power is only exercisable by the people after 4 sequential processes, namely civic education, public participation and collation of views, constituent assembly debate, and ultimately a referendum. 8, the power to amend the Constitution through the popular initiative route under Article 257 of the Constitution is reserved for the private citizen, for Wanjiko only. Neither the President nor any state organ is permitted under our Constitution to initiate constitutional amendments using the popular initiative route. 9, under Article 143(3) of the Constitution, the President can be sued in his or her personal capacity during his or her tenure in office, except for actions or omissions in respect of anything done or not done in the exercise of his or her powers under the Constitution. 10, the Constitution Amendment Bill 2020, which was developed by the BBI Steering Committee and is being promoted by the BBI Secretariat, is an initiative of the President. The President does not have constitutional mandate to initiate constitutional amendments through popular initiative under Article 257 of the Constitution. 11, to the extent that the BBI Steering Committee was employed by the President to initiate proposals to amend the Constitution, contrary to Article 257 of the Constitution, the BBI Steering Committee is an unconstitutional entity. 12, additionally, the BBI Steering Committee is unlawful because the President violated the provisions of Article 132, sub-Article 4A of the Constitution in its establishment. 13, in taking initiatives to amend the Constitution other than through the prescribed means in the Constitution, the President failed to respect, uphold, and safeguard the Constitution, and to that extent, he has fallen short of the leadership and integrity threshold set in Article 73 of the Constitution, and in particular, Article 73, 1A thereof. 14, the history of Article 257 of the Constitution, read together with Articles 95(3) and 109(1) and 2 of the Constitution, yields the conclusion that in order to effectively carry out referendum process as contemplated under our Constitution, it is necessary that a specific legislation be enacted for that purpose. 15, notwithstanding the absence of an enabling legislation as regards the conduct of referenda, such constitutional process may still be undertaken as long as the constitutional expectations, values, principles, and objects, especially those in Article 10 of the Constitution, are met. 16, Parliament and the county assemblies or any other state organ cannot, under the guise of consideration and approval of a popular initiative to amend the Constitution under Article 257 of the Constitution, alter or amend the Constitution Amendment Bill presented to them. 17, Article 255, sub-Article 1 of the Constitution yields the conclusion that each of the proposed amendment clauses ought to be presented as a separate referendum question. 18, Article 89(1) of the Constitution, which provides for the exact number of constituencies, while being part of the basic structure of the Constitution, is not an eternity clause. It can be amended by reducing or increasing the number of constituencies by duly following and perfecting the amendment procedures outlined in Article 255 to 257 of the Constitution. 19. The criteria and procedure for delimitation and apportionment of constituencies set out in Articles 89.4, 89.5, 89.6, 89.7, 89.10, and 89.12 are unamendable constitutional provisions. In other words, they are eternity clauses, and they can only be amended by the exercise of primary constituent power. 20. It is unconstitutional for a constitution amendment bill to directly allocate and apportion constituencies in contravention of Article 89 of the Constitution. 21. The Independent Electoral and Boundaries Commission cannot conduct any proposed referendum because, 1, it has no quorum. The quorum for the conduct of business by the IEBC is 5 commissioners, period. 2, the IEBC has not carried out nationwide voter registration. 3, the IEBC has no legal or regulatory framework for the verification of signatures as required by Articles 257.4 of the Constitution. And lastly, in view of what we just said about the IEBC, all the actions taken by the IEBC with respect to the Constitution Amendment Bill 2020 are null and void. And now, our disposition, the orders that we will give in the consolidated petitions. The orders which recommend themselves, which we hereby grant, are the following. 1, a declaration hereby issues, 1, that the basic structure doctrine is applicable in Kenya. 2, that the basic structure doctrine limits the amendment power set out in Articles 255 to 257 of the Constitution. In particular, the basic structure doctrine limits the power to amend the basic structure of the Constitution and eternity clauses. 3, we declare that the basic structure of the Constitution and eternity clauses can only be amended through the primary constituent power, which must include 4 sequential processes, namely civic education, public participation and collection of views, constituent assembly debate, and ultimately a referendum. 2, a declaration is hereby made that civil court proceedings can be instituted against the President or a person performing the functions of the office of the President during their tenure of office in respect of anything done or not done contrary to the Constitution. 3, a declaration is hereby made that the President does not have authority under the Constitution to initiate changes to the Constitution, and that a constitutional amendment can only be initiated by Parliament through a parliamentary initiative under Article 256 or through a popular initiative under Article 257 of the Constitution. 4, a declaration is hereby made that the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report established by the President, V-Day, Kenya Gazette Notice number 264 of 3rd January 2020, and published in a special issue of the Kenya Gazette of 10th January 2020, is an unconstitutional and unlawful entity. 5, a declaration is hereby made that being an unconstitutional and an unlawful entity, the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report has no legal capacity to initiate any action towards promoting constitutional changes under the Article 257 of the Constitution. 6, a declaration is hereby made that the entire BBI process culminating with the launch of the Constitution of Kenya Amendment Bill 2020 was done unconstitutionally and in usurpation of the people's exercise of sovereign power. 7, a declaration is hereby made that Mr. Uhuru Muigai Kenyatta has contravened Chapter 6 of the Constitution, and specifically Article 73, Sub-Article 1, Sub-Sub-Article A, Sub-Sub-Sub-Article 1, by initiating and promoting a constitutional change process contrary to the provisions of the Constitution on amendment of the Constitution. 8, a declaration is hereby made that the entire unconstitutional change process promoted by the Steering Committee on the Implementation of the Building Bridges to a United Kenya Task Force report is unconstitutional, null, and void. 9. A declaration is hereby made that the Constitution Amendment Bill 2020 cannot be subjected to a referendum before the IEBC carries out nationwide registration exercise. 10. A declaration is hereby made that the IEBC does not have quorum stipulated by Section 8 of the IEBC Act as read with paragraph 5 of the second schedule to the Act for purposes of carrying out its business relating to the conduct of the proposed referendum, including the verification of signatures in support of the Constitution Amendment Bill and Article 257(4) of the Constitution submitted by the Building Bridges Secretariat. 11. A declaration is hereby made that at the time of the launch of the Constitution of Kenya Amendment Bill 2020 and the collection of endorsement signatures, there was no legislation governing the collection, presentation, and verification of signatures, nor a legal framework to govern the conduct of referenda. 12. A declaration is hereby made that the absence of a legislation or legal framework to govern the collection, presentation, and verification of signatures and the conduct of referenda in the circumstances of this case renders the attempt to amend the Constitution of Kenya through the Constitution of Kenya Amendment Bill 2020 flawed. 13. A declaration is hereby made that county assemblies and parliament cannot, as part of their constitutional mandate, to consider a constitution amendment bill initiated through a popular initiative under Article 257 of the Constitution, change the contents of such a bill. 14. A declaration be and is hereby made that the second schedule to the Constitution of Kenya Amendment Bill 2020, insofar as it purports to predetermine the allocation of 70 constituencies, is unconstitutional. 15. A declaration be and is hereby made that the second schedule to the Constitution of Kenya Amendment Bill 2020, insofar as it purports to direct the IEBC on its functions of constituency delimitation, is unconstitutional. 16. A declaration be and is hereby made that the second schedule to the Constitution of Kenya Amendment Bill 2020, insofar as it purports to have determined by delimitation the number of constituencies and apportionment within the counties, is unconstitutional for want of public participation. 17. A declaration is hereby made that the administrative procedures for the verification of signatures in support of constitutional amendment referendum made by the IEBC are illegal, null, and void because they were made without quorum, in the absence of legal authority, and in violation of Article 94 of the Constitution and Sections 5, 6, 11, and 11 of the Statutory Instruments Act. 18. A declaration is hereby made that Article 257, sub-Article 10 of the Constitution requires all the specific proposed amendments to the Constitution be submitted as separate and distinct referendum questions to the people. 19. A permanent injunction be and is hereby issued restraining the IEBC from undertaking any processes required under Article 257(4) and 257(5) in respect of the Constitution of Kenya Amendment Bill 2020. 20. The prayer for an order that Mr. Uhuru Muigai Kenyatta makes good public funds used in the unconstitutional change process promoted by the Steering Committee on the Implementation of the Building Bridges to a United Kenya Task Force report established by Mr. Uhuru Muigai Kenyatta is declined for reasons that we've given. Constitutional change process promoted by the Steering Committee, by the BBI Steering Committee, make good the said funds is also declined for the reasons we have given in our judgment. 22. The rest of the reliefs in the consolidated petitions, which we have not specifically granted above, are deemed to have been declined. And lastly, this being a public interest matter, parties shall bear their own costs. But before concluding, we take this opportunity as a bench. This is on behalf of my 4 colleagues. We wish to express our sincere appreciation to the Council and parties who appeared in these consolidated petitions for their well-prepared pleadings and their well-researched arguments and submissions. If we have not referred to any part of the submissions made or decisions referred to us, it is not out of lack of appreciation for their industry. That is the end of our judgment. Mr. President, may I request you please speak closer to the mic and speak very loudly. It's raining, so we are not hearing you very clearly.
I think it's the voice, the sound.
Is it, just 1 minute, is it ours? Is it at the maximum?
What about this gadget?
Check our volume, please.
This is maximum.
Is it maximum?
Yeah.
Okay. This is for talking, it's not for hearing. Okay. Mr. Harvey, you may please proceed. Just 1 minute. Was that Mr. Mwangi? Oh, it's Mr. Morara. Okay. Okay. I will begin with. I will please begin with Dr. Haminwa out of courtesy for seniority. Dr. Haminwa, would you please proceed first? Okay, so, Dr. Haminwa, I'm very sorry, but we can hardly hear. I don't know, do we know what the issue is?
I mean, we should be having something better.
Yeah?
Can be there.
It has to be ours.
All of them cannot be having some.
Okay. Mr. Hamino, maybe we can just request that you try and shout and see if it will be better. That is better, yes. Dr. Hamino,
a major blow to the Building Bridges Initiative Constitution Amendment Bill 2020 rendered null and void by that 5-judge bench you see there on your screen, sitting for over 5 hours today. and going through that 500-page judgment, 17 issues that were from consolidated petitions, several of them presented around the Building Bridges initiative. They were brought down to 17 issues, and for the last couple of hours, it is what we have seen these judges deal a huge blow, tearing apart, literally, the BBI bill. President Uhuru Kenyatta there indicted the judges, saying that he contravened Chapter 6 of the Constitution by initiating constitutional change. They were categorical that this BBI process was not a popular initiative, that it was in fact a president's initiative, is what the judges have found. You have judges there, Joel Ngugi, Jerias Nga, George Odunga, Chacha Mwita, and Teresia Mathera. So they said that the president disguised this constitutional change as popular initiative, but it was in fact his initiative, and he had no business starting the same. Finding as well that the BBI steering committee judges are saying that it was unconstitutional of an entity and it was unlawful. Some of those directives we have